Hi, my name is Muhammed Yusuf, a graduate intern at HARLEM Solicitors and a bar part 2 candidate at the Nigerian Law School Enugu campus. In this session, I'll be discussing the regulations on mast or towers installation and planning in Nigeria. Before I begin, have you ever wondered why telecommunications masts varies in height? Or have you ever wondered why telecommunications masts are erected or installed very close to your house? Dear viewers, please stay glued to this video and get the answers in the next few minutes. Foremostly, it is germane to know that the principal legal framework governing the telecommunications industry is the Nigerian Communications Act of 2003, hereinafter refers to as the NCA 2003. The primary object of the NCA 2003 is to create and provide a regulatory framework for the Nigerian communications industry and all other matters related thereto. To actualize these objectives, the NCA 2003 under Section 3 subsection 1 established the Nigerian Communications Commission, hereinafter refers to as the Commission. The Commission, upon its creation, was empowered under Section 70 to make and publish guidelines and regulations as it affects the telecommunications industry. In exercise of that power, under Section 70, subsection 2, about 18 guidelines were made by the Commission. One of those guidelines is the Guidelines on Technical Specifications for the Installation of Telecommunications Masts or Towers 2009. Hereinafter refers to the 2009 guideline. Moving forward, by virtue of Section 1, subsection 1 of the National Environmental Standards and Regulations Enforcement Agency Act 2007, there is established an agency known as the National Environmental Standards and Regulations Enforcement Agency. The agency is directly under the supervision of the Federal Ministry of Environment, Housing and Urban Development. By virtue of Section 34 of the Nigerian Act 2007, the minister is empowered to make regulations as it affects the environment generally. In excess of that power, several regulations were made by the minister, but the most important or the relevant one to this discussion is the National Environmental Standard for Telecommunications and Broadcast Facilities Regulations 2011. Hereinafter refers to the 2011 regulation. The NESRIA was created in accordance with Section 20 of the 1999 Constitution of the Federal Republic of Nigeria as amended, which says that the state shall protect and improve the environment and safeguard the water, land, air, wildlife, and forest of Nigeria. The 2009 guidelines permit the installation of new masts or towers in residential areas on the condition that such mast or towers does not exceed 25 meters in height. This is the provision of Section 3, subsection 4 of the guideline. Where a mast or towers to be installed in residential area exceed 25 meters in height, the permission of the NCC must be sought before such installation is carried out. As such, a mast or towers in excess of 25 meters in height shall be placed at a minimum setback of 5 meters from the nearest demised premises, excluding the fence of such demised premises. This is a provision of Section 3, subsection 4 of the 2009 guideline. How do you measure the 5 meters distance? You measure the 5 meters distance from the nearest foot of the tower to the nearest demised premises, excluding the fence. Furthermore, the 2009 guidelines stipulates that no masts or towers, regardless of its height, shall be erected within 15 kilometers of any airport or within the proximity of any helicopter pad and their approaches without prior approval and permit from the Nigerian Airspace Management Authority. Also, Section 9, subsection 1A of the 2009 guideline stipulate that the maximum height of a mast or towers in commercial or industrial areas shall not exceed 150 meters unless the Commission is satisfied that such increased height A will not be detrimental to public health, safety, and general welfare. B. That the increased height will not have any negative effect on the neighborhood. C. That the increased height is in conformity with the plan of that particular area. D. That the increased height will not impair compliance with any other applicable laws or guidelines. Where a mast to be installed in where the permission um, of the commission has been granted to install a mast in excess of 150 meters. Such a mast shall be placed at a minimum setback of 50 meters from the right of ways of all controlled access, federal and state roadways designated as freeways. Next is the main thrust of the 2011 regulation is to protect environmental and human health, ensure safety and general welfare, and minimize public and private losses due to the activities of the telecommunications and broadcasting industries. By the provision of Section 5, subsection 4, paragraph 1b and c of the regulation, a minimum of 10 meters setback from the perimeter wall or fence of a residential area, schools, and hospital is mandatory. Where there is no perimeter wall or fence, 12 meters setback shall be allowed. It should be noted that where the NCC in its guideline stipulates 5 meters setback, the NESREA in its regulation make provisions for 10 meters setback. As such, there is a conflict as to whom between the two federal government agencies defines setback and which setback to comply with by the telecommunications companies wishing to site a base transceiver station, that is a BTS. The conflict was brought to bear by the sealing of a telecommunications base station facility belonging to MTN located at a Fab Estate in Mbora district in Abuja by the NESREA. The NESREA were claiming that MTN failed to comply with its regulation before siting the facility. So, upon sealing that facility, NCC went to that site and unsealed it. NCC states that MTN has complied with its own guidelines, which stipulate 5 meters setback from the nearest demised premises. And NCC insisted that they are the only agency that have that power to regulate the telecommunications industry. As if that was the end, NESREA went back to that site and resealed it. They claimed that NCC had no lawful authority to open that facility. The NESREA insisted that MTN has not complied with its regulations, which stipulates 10 meters setback from the nearest demised premises. The conflict lingers and it caused a lot of tongue to wag. Later, the two ministries, that is the Ministry of Environment, Housing and Urban Development and the Ministry of Communications and Digital Economy, met and resolved that henceforward the minimum acceptable setback from the nearest residential area shall be 10 meters. And where the 10 meters is practically impossible to achieve, 7.5 meter setback shall be allowed. And that has been the requirement ever since 2012. Dear viewers, for more information, please visit our website at www.harlemsolicitors.com or visit our LinkedIn page at HARLEM Solicitors. Thanks for watching.